Before I start, I too would like to acknowledge the address we had to open this up, and it made me think about we sitting here, many of whom, not all, are descendants of the colonisers of this region and others in Australia, sitting in an institution of enormous wealth, of learning in Western values and so forth, and to think of the people that this all displaces who had their own religious and intellectual traditions dating back in this area so long. I think it behoves us to not just give a formal recognition, but to recognise this is an ongoing different part of colonisation, the maintenance of wealth and so forth, and that institutions like this have and people like us have an obligation to, as best we can, to help address that terrible disparity. Being elderly and irascible, I reacted to the jury decision and, amongst many other things, this widespread poison of the apical ancestor, which has been grabbed with alacrity by the legal friends who are not present amongst us, fortunately, and who fail to understand that simply defining a group by an apical ancestor will have the absolute, maybe unintended consequence, but what I call a governance catastrophe by the time we hit the second generation down. That is, if you think logically, you know, old fella Martin, the great-great-grandfather, each generation you go down, you increase the number of people who can trace that. And already, where I'm very familiar in Cape York, this is causing, as I say, a governance catastrophe because everybody ultimately will be able to claim every part of Cape York. It's a nonsense, it's a fiction. And so, if we could go to the next one, thanks. So, what I want to do very briefly here is to canvass a set of suggestions for how we as anthropologists manage these cases, like the jury, or dealing with lawyers who talk about the apical. They don't even have anything, it's just the apicals. Ooh, that's exciting. So what I want to do is to think through, going back to basic principles of what is native title and what is our place in the native title system. So the first thing is the definition in section 223 of native title. I find it extremely useful when going back and thinking about this because at this point it hasn't codified. It simply says that native title is a set of conditions. It's a recognition. I'll come back to that. A recognition by Australian law. But when the people who are claiming have, under those laws and customs, under their laws and customs, a connection with the lands and waters claimed. Now that's a very, very useful generalised statement. It gives us as anthropologists, in my view, a non-specific lever to talk about the nature, the kind of things that we heard just before, the kinds of connections and so forth. It helps us to give a whole set of connections. There will be people with connections to an area who, to use today's parlance, can speak for that area, and others who might have a right to use and occupy. For example, a man who in traditional society is living with his wife's people, that man has rights in that area. He has the ability to hunt and do various other things, but he can't, his own rights and interests in his own country have no relevance there. He has a right to do it, but it's not a right that arises from ownership. It's a right that arises from legitimate occupation, you might say. So if we could go to the next one, thanks. So and these are all things that many of you have had the misfortune of having dealings with me, including Yamaji over the years, will know that I've used this diagram often, but I find it extremely useful to conceptually separate not just what Australian law is and native title, but to see it as where we are as anthropologists who are working in this arena. So what native title does in its legal system, and in particular it's its property system, its property law. Australian law establishes rights and property as a bundle of rights. Those of you who live in Perth and you're lucky enough to have your own house and so forth, is a set of rights that you have, a bundle of rights as the owners of that country. That's the Australian property law system. As we know, all of us who are anthropologists who work, and it would be true in heritage as well as in native title, it's an infinitely more complex world of multiple layered kinds of connections. And it's what I'm saying is a system of traditional laws and customs through which connections to country are held. And this is a recognition space between two systems of law. Australian law, following Mabo, treats the Aboriginal systems, the Indigenous systems, as law for the purposes of the Act. We go to the next one, thank you. But it's not just a recognition space, it's also a translation space. It translates from whatever the nature of those connections are, that system of connections that research finds out that Indigenous witnesses themselves give testament to and so forth. It translates that complexity to forms that can then be cognizable to, can be interpreted or transformed or translated into the kinds of rights and interests we see in native title determinations. The right to do X, the right to do Y, and so on and so forth. So if we go to the next one. Whoa. Okay. The point I'm making there is all of us who've appeared in front of the courts, all of us who've signed documents who are either working internally in a land council or a representative body, or who people like me are doing this as someone engaged from outside, we all know roughly, at least, what is an expert. We know that an expert, as defined by the law, is someone who is held to have a specialist knowledge, experience, and so forth. The lawyers and judges are extremely vigilant in ensuring that we do not transgress that rule of expertise. The other thing, of course, is that expert has a duty to the court and not to the people who engage she or he. So we're constantly aware of that, and yet the thing that I find frustrating and I think we can do something about is they also ask us to give opinions on matters which are legal concepts. Native title rights and interests is not a term of anthropological art. It is a legal term with a set of attendant characteristics set by Mabo, set by the Native Title Act, and set by, as Louise mentioned, by jurisprudence. But it's still a legal concept, and those of you from Yamaji will know that in the work that I was lucky enough to be able to do with Nissa Cahoon, who's here I think, and Carmen Cummings in the Ngulli claim in the Gascoyne region, we determinedly avoided giving opinions or giving information on the legal concepts, but rather we did it on matters which we felt were, for example, connections of a possessory nature. are the sort of things that could be translated by the lawyers into the native title concepts. So basically, as I see it, the way of anthropologists working is to not give in to implicit and sometimes quite explicit demands from lawyers, but we give opinions on matters of law, like does this group, I've had briefs which I've refused to accept, which say, please, 33B subsection 3 says your opinion on whether the group holds native title rights and interests. I will never answer that. What I will say, I'll set out my reasons why I can't, and then I will say, however, I believe in my research, the research of those before me, what I've heard from the people with whom I've worked there, that these are factors, for example, which go to who can legitimately talk for a country as opposed to others who may be able to access it but can't. And in particular, those who can talk for country and have the right to pass that on to their descendants, which is something that other kinds of connections don't necessarily do. It applies to them, but not automatically under the system to their descendants.
5 minutes.
Good, nearly there. That's the act that's the description of section 223. We can skip through that. Keep going through, and I'll. Okay, so. What do we say if we take this view that we should as best we can do what we're asked to do as specialists in this arena, as not transgressing into the case itself, but rather setting out, assisting the court by the kind of let's call it translation of the concepts into forms which are cognizable to the law, then I think it also gives us a chance to think about how do we respond to a group, Drury, roughly. What it would mean, what it basically says, as Louise put it, there are two entirely different systems of law and custom which overlap. I stand to be corrected by the many experts in the room, but I'm not aware of any system, any region that I've had any dealings with, and most particularly Cape York, where I spent a lot of time and research and so forth, where there's two different systems. The systems merge and link into each other, but you don't have two, it's not possible. That's the first thing. The second one is, what I think the jurisprudence is not aware of is that almost everywhere that I'm aware of, language is not simply a property of a group, like we talk about in Europe and so forth. It's far more than that. Language is emplaced inland by the creator beings. It's not just left for those people, it is part of that landscape. And you cannot understand this group's emplacement of this land in this area without understanding that there is the mythology everywhere I'm aware of, not just in places that there, but sets up more or less a boundary point of some kind, and also emplaces the next language. There is a regional system in which language and people and the totemic beings are emplaced. It's part of this all-encompassing system. And to this kind of thing is simply nonsense. Now, is there another one? I think that's.
If there is.
Yeah. I'm cantering through against great odds. What my call is to think about, and the only claim we did this is to first, can we be truer than we have been? Can we resist the kind of demands of lawyers to give them what amounts to legal advice? Can we be more creative in thinking through how can we set out these complex worlds in ways which can be translated by the lawyers into native title rights and interests and the various other things. So that's my question, and that could be seen as just bad ethnography. But the way I tend to look at Drury is to say that is not the ethnography. That is the product of the Australian legal system, and in this particular case, this is the impoverished and incorrect translation which the courts has offered, but it doesn't actually mean that the ethnography is any different. And a mistake that I feel even senior lawyers and judges make is to assume that what they are setting up is in fact the system. It's not. It's a recognition of the system that doesn't take into account the actual ethnographic realities of that system. Thank you.